Well, Thomas Mathiesen, I'm very pleased to have you here in the sofa for a discussion about sociology of law.
I'm too very happy with it.
In a Scandinavian perspective, in a sense. I mean, Norway is famous for being one of the leading institutes in sociology of law, and you were one of the forerunners in that. I would like to start to ask you about sociology of law. When did you come in contact with the subject, and what does it mean for you?
Well, I began my studies in the United States, and it was a major experience in that stage, at that time, to study sociology in the States. We were far away from Harvard. We were far away from Talcott Parsons and associates, and we had to read some of it, but not so much. And I got into contact with a very, at that time, rather famous professor of sociology, and he took care of me in a way. And this was a good time in my life. Then I came back to Oslo and entered sociology in Oslo. At that time it was a small institute or department with a few students and one professor and a couple of assistants. And I look back on this period, which lasted for 3 years, 3 years, as the worst period in my life. It was a fantastic and sort of rather terrible change from the United States to Norway at that point. And I won't go into details about that, but
what was the problem?
Well, the problem was mainly that we had to read Parsons.
And only Parsons.
And more or less only Parsons, and some other Americans.
Yes.
Whereas in the States I had learnt about Durkheim and Max Weber and Simmel and Tönnies and others, European sociology essentially. So we had to learn to read Parsons, and we had to learn to think in several levels, as it was formulated at that time. Then after 3 years I took my master's degree, excuse me, and I went over to the Institute for Social Research, where there were people like Willem Aubert, Erik Linde, Sverre Lysgård, sociologists in the making, but a little older than myself. Willem Aubert was 10 years older. He was the oldest, belonged to the oldest generation. I belonged to the second generation.
Would you say that he is one of the founding fathers of sociology of law?
Excuse me, yes, I would definitely say so. He was a founding father in Norway. There were others before him also, but they were quite a bit less important. I entered the institute in 1959, and in 1960, after a year, I began my first own large-scale study, empirical study in sociology of law. That was a fieldwork expedition, sort of, to a Norwegian prison outside of Oslo, where I spent 2 years as an observer. And it was a formative experience. It was a fantastic experience. Quite different from what I and other people had expected. And I found that claims of injustice were important claims on the part of prisoners. Injustice and inefficiency. And the staff, the governor, the doctors, because this was a medium security prison at the time, and a somewhat treatment-oriented prison with several psychiatrists and so on. They were staunchly criticized for injustice in various forms, a bit like, I haven't read it yet, but I know about it, Barrington Moore's rather famous book from '78 on injustice. He, you know, had an office near Rawls, who wrote the famous book, The Theory of Justice. And he didn't want to read Rawls before he had finished his own book. And his own book did not present a theory of justice, but a theory of injustice. I called it a kind of censoriousness on the part of prisoners towards the system. The government and the governmental ranks, the treatment-oriented personnel and so on, had basically an unjust basis for their operations. This notion of injustice among the prisoners and inefficiency on their part, I mean, attacking the prison orally and morally, has been with me ever since, and essentially is a basis for my engagement in other matters, like action research in various capacities, and the notion of the unfinished, which we can come back to, in various capacities. The idea that from below the law looks different from what it looks like from above. And the above and below kind of dichotomy. But one important connection or line has been from the prison to surveillance. In a sense, you could say that surveillance is representative of the prison outside the prison. How surveillance functions as a kind of prison outside. And that, of course, is a major really line and connection. Secondly, there are many other features of life. The interest of other sociologists in the development of surveillance and the connections to the net society and the dependence of surveillance on using the internet and net-based activities. Surveillance is the institution which really is into the information society in this respect. But an important connection for me was from the prison inside to the prison outside the prison.
We are all prisoners in that perspective.
We are, in a sense, all prisoners, and increasingly so. That's a major point. Not only those who the state wants to keep track of, but ordinary civilians, you and I, we are in the net of surveillance, increasingly so. Not so much by Schengen, because Schengen is a border activity, creating the EU into a kind of fortress, Europe as it's sometimes called. But the other major data collections, the data directive, for example, all traffic, telephones, mobiles, internet use, etc., will be recorded and kept for 1 year, 2 years, what have you. So we are really into a kind of prison.
And that means that the surveillance system can be used not only for controlling the citizens, but also for exploiting them as consumers and so on, I guess.
And this so-called social systems, or Twitters and Facebook and so on, which have come now, of course, recently, are a lot of fun, a lot of jokes, a lot of really nonsense. But this is, of course, data for people who want to use it as data, and chopped up into small bits and sold on the market. This is one of Fuchs's major points. Sold on the market to the highest bidder for advertisements, for use in advertisements. And that's an important feature of surveillance, really, also.
You have talked a lot about your experiences from action research, primarily in relation to studying prisons. Are there any general conclusions you can draw from these experiences into other areas of society? Or how contextual specific are these kind of knowledge you produce via action research?
Well, it's not it's not really contextually specific. I've used this kind of methodology in prisons, but there are many other contexts in which action research may be relevant. There are, of course, also other conceptions of action research. For example, that you provide people with aid, and in return you get information, like legal aid, for example, is here used as a conceptualization of action research also, in a different sense. My idea of these circles is not the only one. And but I think it's very important in the question of how to create and sustain a movement. Not an organization, but a movement.
So you can also draw some general conclusions out of your experiences. I think of your book about the unfinished and your ideas about the in definition and out definition of individuals in certain situations.
Yes. And all of this, incidentally, is out in English. So also the hidden disciplination, which I gave a different title in English, but it's definitely out and translated. And yes, one very important general point coming out of this is really who defines the situation, who has power to define the situation. Well, the state has that power. And when that monopoly is counteracted by people, you are in a kind of revolutionary situation, like in Libya now. Of course, Tripoli has been taken, Gaddafi is away, and the people somehow, it may not stay on, it may change, but the people now define the situation as what is real. So the definition of truth is a man-made thing, really, from above, usually, sometimes from the bottom. It's a natural continuation into action research. When you start looking at law as a matter of injustice, you also start thinking that something should be done about this, and that leads on to action research.
And with a bottom-up perspective
Yes.
also, I guess.
Yes. It implies this, that if you contrast action research with ordinary research, ordinary research implies that you find some data in some way, by observation, by any kind of method, and you analyze those data, and the analysis leads on to an improvement of a theory. And the improved theory goes back to the data, or assembly of new data, and the analysis of those data go back to the theory, and so on in the circle. My idea with action research, there are several other conceptions, but my idea with it is that you have data assembled not by traditional methods usually, but by participation, like I did in the
prison case.
And in the movement Krum afterwards. And I tried to bring those data analyzed back to the movement, not to theory, but back to the movement. And that would mean you got into a confrontation between the data and the movement. Is this in the interest of the movement? It doesn't mean that I hid any data, and I want to be explicit on that. I never have done that. I've never never hidden anything which I knew from the organization, from the movement, and then back from the movement to the data gathering and so on in an alternative kind of circle. My point being also that this makes it possible for a movement to remain a movement and not become essentially an organization, not become a bureaucratic structure with voting and those who have most votes win and that kind of thing, but it leads to a movement which remains a movement, and that's how you make a movement essentially, and how you can also plead for a continuation of the movement, which the Norwegian case is somewhat an example of, in that we have this organization still. It goes up and down. It can often be down and be very little, but it can also be quite a bit. But then, of course, that circle between data and action and back again to data and action stifles you after a while. So you have to end up again for a while in theory. So there has to be a dialogue between action and theory also. And that stifles after a while, and you go back to theory, back to action, and getting the information back to the movement. And so you have to vacillate between the two. This is essentially the life of an organization, to see those two circles going in a kind of parallel way, and without being so much in touch, and also a combination of the two circles. Because I have, of course, in my concrete work with these prisoners for all those years, and conferences and books and what have you, I've also had use of sociology, theory.
What kind of conclusions, general conclusions, can you draw from your experiences you have talked about here now?
Of the action research.
Yeah.
Well, I think there are several general conclusions. One of the major conclusions is really the idea of how a movement is created and kept alive, which we have already discussed a little bit with the two circles which I mentioned, and the one circle going to the other and back again, and so on, and a different kind of circle for action research. There's a second learning point, in a way, in this thing, in my opinion, and that is phrased in my mind in several of my books as defining in and defining out. The point is this: as I said, if we had accepted, say, an office, a small office, or a cup of coffee even, from the Ministry of Justice in the beginning, we would have been defined in. We would have been we would have become part of the establishment, essentially. And I think many organizations go this way. There is another possibility, and that is being defined out, which means that you are defined as outside the society, the world. You can say what you want because it isn't important. It's outside. You are defined out. And these are two major structural positions, really, which envelop people. And the state is essentially, I would say, basing itself to a large extent, not only, but to a large extent, on defining groups and people and categories out and defining them in. Either you're inside and with us, or you're outside and don't have a vote. And the important thing with the theory of the unfinished excuse me, is that you don't really remain defined in or defined out. You insist on making your own choices. So if the state tries to define you in,
you resist.
You resist, and you can resist at any time. You are free to bring in any kind of idea in a debate, for example. We have discovered that in our work with prisoners at meetings. Not our meetings, but at ministerial meetings, for example, where I've said something and I've been sort of defined out a little bit because I'm an academic, I don't know my business. And then the prisoner comes up from the organization or movement and says something, and he's the opposite. He's in sense inside, from one point of view anyway. And this way we can move back and forth at the meeting. I've discovered this many times. And not accepting the state's definition of us either as defined in or defined out, but as something in between, something unexpected, something unanticipated. And I remember in the beginning this notion, after I wrote the first edition of The Unfinished, this created a great deal of anxiety and stir, really, among prison officials and people in the bureaucracy and so on. And I remember a major article in Dagbladet by a prison governor who said, "This is dangerous. This man is dangerous. We can't place him. We can't place him either as defined in or defined out. Is he a revolutionary? If he's only a revolutionary, he can be defined out. Is he a reformist? If he is a reformist and only that, he can be defined in. But this man, or these people, are both. And they change whenever they want to. And how can you have dealings with such people, you know?" And he's probably right. Maybe we overdid it a little bit at that time. But
But that was a point, I mean, in your strategy.
That was a major point in my strategy.
Not to be
and I brought-
captured.
Yes.
As I remember your book about the unfinished and this discussion about in and out definition
Yeah.
is something which is general and not only
Yes.
possible to apply
Yes.
in the prison
Definitely.
case. And you have also been involved and applied this in kind of action research, I guess, in other areas. But I know that the prison case is your main
Has been my main, because there I've had
main
this
focus. Yeah.
main focus because of the early experience, 2 years daily.
But how about, for instance, I recall the Alta case.
Yes.
How much have you been involved in the environmental movement and or was that one case?
It was primarily, I would say, a one case, because it was so much debated. But I'm of the opinion, really, that all kinds of experiences which you have are experiences which may be interpreted sociologically. So experiences like this are really important. To experience the real life that you go through yourself is important.
The advantage by using action research strategy and also, in a sense, I guess, this personal approach is related to the kind of knowledge you produce, I guess. I mean, it's not a question of filling holes in already theoretical, on a theoretical map.
No. I could never, for example, I don't think I would do it well enough, go into Luhmann and fill in a spot or two or three in Luhmann. That would be a difficult task anyway, I suppose. But or for that matter, in the old days, Parsons. Or others. And
Parson was Luhmann of that time,
It was Luhmann of that time, you see, definitely. There are some similarities and some binding points. Well, you mentioned Alta. That was also a personal, to me, a personal experience, which I analyzed sociologically, and also from the point of view of legal sociology. And it's not a book on my part. I didn't know enough about the environmental issues involved really to write a book, but I've written several articles on it. And Alta became important as a legal case, especially, because
it was brought to all the way up to the Supreme Court, wasn't it?
Yes. You see, in the beginning, there was essentially no legal question. The demonstrators, and I was one of them, I participated as a demonstrator. We said essentially that this may be wrong from a legal point of view to sit here, that we may transgress the law this way, but that's civil disobedience, and we do it anyway. And we were brought down by the police and were fined and so on. That's a long story of itself, which was very interesting. But then someone, the beginning came, I think, from the lower court, asked the question, are you sure that the state has been legal in all its business in this case? And then we said, well, the state, that's a different issue if the state isn't quite legal. And then in the so-called Herredsrett district court, it's set up in a special manner with the cases of remuneration for taking property away of people. And property had to be confiscated here, of course, to build this dam and the road to the dam. So the question of money came up, and the owners lost the case. They argued for a tremendously large remuneration, and they lost the case. It was 5 for them and 6 against them, or something like that. It's a large court. And then the case went right to the Supreme Court, which had at that time anyway 17 members, and 1 abstained, so there were 16. There were 17 altogether. So there would not be. So there would be a majority and a minority, and the state won against 0 in the Supreme Court. And our thinking was then, frankly, I warned them a bit against this, but let me include myself also. Suddenly it became very important. Well, if it's illegal, if the state has acted illegally, that's a different issue, of course. And our thinking about civil disobedience and so on disappeared a little in the background. And the Supreme Court verdict was very important in stopping the whole thing. I think without that verdict, without that question raised, we would have continued quite a bit longer. There were reasons for also other reasons for stopping. The fines got very great.
Stopping the demonstrations or the protests.
The fines were very great. They began at 3,000 crowns and it ended at 20,000 crowns. But well, in other words, the question of legal sociology came up very acutely in that court case.
And as I recall your position at that time, you in a sense, you were critical against the going the legal way due to the fact that then you are captured in a sense.
Yes.
Because it's not you any longer who define the problem,
That's up to the court.
You are up to these lawyers to decide.
Exactly.
And of course, that's one important reason for law many times to be the to provide with the end solution, so to say, in a case.
That's right, precisely. And that was very important. In this
But let me ask you, Thomas, haven't you had any problems in relation to your professional academic career, being methods like civil disobedience, action research, and so on?
Yes.
You have been engaged in the problems in relation to the information technology, or you have followed the implications of this new technology on law and on socio-legal issues. Could you elaborate a bit on that? Because you have mainly focused on the problems with surveillance, or the let's say the growth of surveillance possible by the new technique. And you have also talked about this in terms of lex, if I remember correctly, vigilatoria, as a kind of pendant to lex mercatoria, which is a global phenomenon, and this seems to, in your mind, to be a global phenomenon, this surveillance going all over the globe, more or less.
Going all over the place. And in a case somewhat as if it was a law without a state.
That's your point. Exactly, which Günther Teubner has addressed.
Of course. So I'm basing myself on Teubner in that context. I don't know quite whether this holds as well for lex vigilatoria surveillance, but it's an idea anyway. Yes, I've written a book in Norwegian on on the surveillance systems in Europe. Schengen Roman numeral 2, which is coming up in 2013, and Eurodac, Europol, and all of these other kinds of systems, which I think are increasingly integrated horizontally between the systems. Whereas at the same time there is a weakening of the systems in relation to the national state. So that's why it's an idea which is a little bit like Toibler's, a law without a state. In other words, maybe it goes towards an integrated, full-scale, one big system.
What brought you into this interest for surveillance?
Well,
is that a prolongation of the interest for the prisoners?
Yeah, it was a little bit, you see, because it came out as a kind of parallel to prison issues. But it was not the same, of course.
Kind of expansion of the idea about the closed institution, the prison to the state. And
that's right. That's right. And so it was inspired by that. It was also inspired, of course, by the general development in the world as we saw it from a Norwegian point of view, anyway, and the development towards a great deal more surveillance. And I've thought of the idea which you brought up to a considerable extent of the development of our society from an industrial society to an information society, but information used negatively. And as things develop,
now they come and get us, I guess.
Yeah, that's right. Yeah. As things develop and as things go and time goes, I think there's more to this than I've thought in the beginning. I wondered whether the state can be viewed as not pulverized, but chopped up in various brackets. You have religion as an institution. An institution to me is a set of values surrounded by norms, norms for action. Institutions are in varying degrees up to a change towards an information society and surveillance, and that part of police activity is way ahead. The normal police, the regular police, is not so way ahead, because they say roll out the computers in their cars, but they hardly use them. I mean, what the criminal case concerns is good, solid police work.
Your view on the European Union and what role law plays in the creation of the European project. I know from one of your textbooks, Law and Society, that you talk about let's say the interaction between law and society, and law is influenced by society, and society influenced by law, etc. What comes first in relation to EU, society or law?
Yes. Yes.
I guess usually society is the foundation or the substratum, for using René's term, for creation of law. But is there a society on a European level which you would say is the initial phase of creating law on a European.
I wonder if in this case I would say, I haven't thought of it just in this way, but I would perhaps say that law comes first. Law came first at certain strategic points. Agreements between states transposed into law, and then adherence to the law from the various states. For example, well, in Schengen, which is a border activity, which of course especially keeps out foreigners and control the border, the common border, I mean the third issue border, whereas borders between Schengen states are, if not erased, they're not that important anymore. Law came first. Law came, I would say law came in 1985 when the Schengen arrangement was politically agreed on, and 1990 when the Schengen arrangement was made legal and a binding case for all states then in the EU. No, not society in the case of the civil world anyway. Anyway. It would be politicians and people knowledgeable about digital methodology and so on. But it was those people rather than people in society, in civil society, that were important.
And what is in your mind lying behind the creation of EU? What are the driving forces?
I think it was an important. This is contrary to my beliefs, sort of, but I think it's true. I think the beginning of it was partly a matter of keeping the peace. We won't have one more experience with Germany going out and creating mass killing and a war against the rest of Europe, and for that matter, the world. This was, I think, in the minds of the politicians at that time, that keeping the peace, this would keep peace, binding Europe together in economic arrangements would necessitate relative peace. I think that was the beginning. But then, of course, you could say that after 10 or 20 years, commerce and trade and, in general, economic features had a massive influence on creating the EU and following up the EU as something which could further be created. Now, of course, comes North Africa as a part of the issue. And Italy's, France's response, Sarkozy's response to this, and Berlusconi's response to this, with 20,000 Tunisians coming to what is this island called again, this Italian island, and then on to Italy, and sent on trains to the French border where it stopped. All of this creates the need for a kind of basic reform of some of the legal aspects of the EU. So perhaps we are into something where the law has begun the race, motivated by peace after the World War. But then it has turned into a situation where society is not only a respondent, but a creator of new reforms, legal reforms, because of the uproar in all of the northern African states, and the France or Italy couldn't at all keep their hands on the wheel during these weeks and months that this uproar and refuge took place, and society was involved. Not necessarily European societies, but then outside societies.
You and others, I guess, have used the metaphor of putting that Schengen means that you put a fence around Europe.
Fortress.
Yeah.
Yes, a fortress.
And of course, it's a kind of controversial thought, but does that have something to do with peace also?
I don't think they thought about that in 1950.
No, but I think when you create the Schengen today, that Schengen is a way of
well,
keeping a peaceful Europe for itself, so to say.
A peaceful Europe, yes. It could mean that it makes for a peaceful Europe, and yet there are lots of wars in the world. So in a sense, you have transposed wars to other parts of the world, and even Norwegian fighter planes are all on the wings all the time, of course, bombing Libya and elsewhere, and so are Swedish, I suppose.
Yes.
So we are at war, and the United States has now 3 major wars going on simultaneously and are broke, which is interesting in itself. Norms and laws are difficult to entangle because in many societies people have norms which have the character of laws. They have to be followed and you have to abide the norms. But there is one major difference, and that is the systemic character of laws. I mean, you see the systemic character of laws when you go to the faculty here. They work on loopholes and conflicts and troubles with laws in interaction. It has to be a system in balance, and it has to be a system, at least. It is systemic. And I suppose that's all over the Western world, a systemic system of norms that becomes laws. And I would think also that anthropological literature would show you that norms become laws when they are systemic there also, to a large extent. I mean, Inca law, I don't know anything about Inca law, but I think we could speak about Inca law if you think of whether it's a systemic or a system. And there were priests and leaders working on, I suppose, the conflicts and in the problems of the relationship between norms in Inca law.
Let me take this up and make two brief comments. The first reflection, I think, is in relation to what you say, is that Niklas Luhmann's description of law is just what you're talking about.
Yes.
I mean, the idea that law is a system of its own and with the characteristics of system. And the other, and that I think, by the way, is a kind of, if not historical parenthesis or within brackets, it's something which belongs to a certain period in development in society. The one very mature kind of society. But the other reflection I think is relevant here is that if we accept that some norms become law, you have to ask yourself in the first place perhaps, why do some norms are they adopted in a legal system? And just to give a short kind of idea about that is that they are strengthened in a certain way. They are strengthened by being related to not only institutions, organizations like the police, the courts, and so on and so forth. And another interesting idea in relation to that, which also one of my younger colleagues have actually brought up, Måns Svensson, is that law intentionally try to imitate being a system in order to strengthen its normative power in itself.
Yes.
By being a system, I mean it gives the normative, the norms another kind of power and status. So in
by
that,
imitating
by imitating natural systems, and also like I mean, I think we are quite aware and accept economy to be a quite consistent system. Not to talk about technological created systems in relation to nature. So law might be a kind of creation of norms in order to operate different problems, social problems in society.
And my sort of thinking about this is, does this also hold for non-Western societies?
I guess so. Even if both you and me, I think, agree that legal anthropology is a bit underused and underestimated, because using a legal anthropological method in present-day society, in modern society, would be very interesting. But because I think there are similarities. I think more and more of anthropological methods are used in sociology today, and also it's could be used to a much larger extent in legal sociology, I think.
Yes, I would think so too.
Of course, it's a question of what we talked about, resources. I mean, it's legal sociology is still a small subject compared to both sociology and law, which is astonishing in itself, and might need explanations from sociology of law point of view.
Yes.
But that's another thing.
That's another thing.
But otherwise, then I would like to put the question back to you, because in my understanding of norms, and I try to make that explicit in the article where I start with commenting your distinction between the norm model, where the norms play one part of explanations in society, and I can fairly well understand and of course accept that as a description of earlier use of the concept of norms. But since I then try to expand the understanding of norms not only to visible interaction between individuals and actors, but also as a kind of guiding, stemming from, emanating from the rationality of a system like that. I mean, if we act on a market, we are forced to follow certain fundamental rules and norms, and if we act within a bureaucracy, within a law faculty, as you used as an example, we have to follow certain hidden implicit norms and rules. Yeah. Do you accept that?
Well, yes, I do. I do accept that. Yes, mostly.
Mm.
I haven't really thought about it that way,
Mm,
but
yeah.
I would say I would accept that. I remember my first meeting in the Faculty of Law. I went into the room. It was a council meeting. It took place once a month, a Tuesday always, 12:15. And I went into the room and sat down. I was then a professor and could do that. And then the dean said, "We have a new professor here, Mathiesen. He deals with prison issues and so on. And he's new, but that doesn't make any difference," he said. And then he said, "And Thomas Mathiesen has now sat down in a very dignified place, on a chair which is very dignified." And I sat right next to the dean, you see. And so in the following years I sat...
Moved.
Yes, I sat down there following the regulations and rules that sat at the furthest end of the room.
That is probably an example, could be used as an example of a kind of self-regulation. I mean,
Yes.
you don't have to force you. They didn't took you
No,
and forced you physically to
physically
moved you physically.
Moved me down. No.
That's and
It
that's
was
I
entirely up to
mean
myself.
that's reflecting to a certain extent the difference between legal roles or roles in a formal sense and norms in a more
Yes.
social sense.
Because this was a norm in a social sense.
Thomas, I think we have touched upon a lot of
Yeah.
exciting issues and problems you have addressed during your academic
I think we have,
career.
yes.
And I think what you have said will help us to learn and,
Well,
continue the
Yes.
way of doing research.
I'm sorry that my voice has been so bad. I didn't expect it to be this bad before we started, but
It's
so I'm sorry about that. But
it's no problem.
Yeah.
Anyway, thank you
they
very much
probably
for this.
understood it. Yeah. Thank you.
Thank you.
Thank you.